Let's jump right in. Welcome to this explainer. Today we're unpacking a truly incredible legal showdown from a 1999 South African constitutional court case. We're looking at a highly fascinating scenario that asks what happens to fundamental human rights the second you put on a military uniform. It's a topic that touches on the very core of how a democracy defends itself while simultaneously protecting the rights of the people doing the defending.
Now, the core philosophical question here is simple, but man, is it profound. Can a soldier strike, or do they just surrender their constitutional rights the moment they enlist? Think about it. When you sign up to protect a nation, you agree to follow orders. You agree to submit to strict discipline. But does that mean you leave your fundamental rights as a citizen right there at the gates of the military base?
To figure this out, we're going to walk through this case by looking at 5 key areas: soldiers versus the state, the ban on public protest, whether soldiers are technically considered workers, the right to unionize, and finally, the court's ultimate verdict.
Starting with Part 1, Soldiers versus the State, and that initial clash.
We are looking at a landmark 1999 judgment where the South African National Defense Union took the Minister of Defense to the Constitutional Court. You have to remember the context here. South Africa was a very young democracy at the time, having just recently adopted a progressive constitution with a super robust Bill of Rights. The big question was whether the existing older military laws were actually compatible with this brand new democratic era.
The whole dispute centered around the severely outdated Defense Act of 1957. Specifically, Section 126B of this act strictly prohibited members of the permanent force from joining trade unions, striking, or participating in literally any form of public protest. And if a soldier violated these rules, they weren't just getting a slap on the wrist. They were guilty of a criminal offense and could literally be thrown in prison. The union argued that this was a massive violation of their members' constitutional rights. The state, on the other hand, argued that these bans were absolutely essential to maintain a disciplined, effective military.
That brings us to Part 2, the ban on public protest and silencing the ranks.
I want you to hear just a snippet of this law's definition of public protest. It was a 255-word, single-sentence definition. I mean, it is so grammatically clumsy and elusive that it completely defies simplification. The court itself even noted that figuring out what precisely was prohibited by this law was no easy task and perhaps even impossible. It essentially banned attending any meeting to support or oppose almost any policy of the government or even the policies of foreign government.
And that brilliantly illustrates exactly why the law was so absurd. Under this insanely broad definition, an off-duty soldier wearing plain civilian clothes could commit a criminal offense just by attending a meeting about foreign policy. They couldn't attend a gathering to discuss NATO's intervention in Kosovo or protest foreign nuclear weapons testing. As one of the judges pointed out, the draft was so sweeping that a uniformed soldier privately complaining to their partner about their work conditions could technically be prosecuted for committing an act of public protest. No way, right?
Well, the court wasn't having it. They found this to be a massive, unjustifiable infringement on Section 16 of the Constitution, which guarantees everyone, and yes, that includes soldiers, the right to freedom of expression. Freedom of expression is the absolute heartbeat of a democracy. It allows citizens to hear, form, and express opinions. The court ruled that enrolling in the military doesn't mean a person detaches themselves from the interests of ordinary society. Soldiers are still citizens. Sure, they have to perform their duties in a nonpartisan, dispassionate way, but they absolutely do not lose their right to have an opinion the second they clock out.
Which moves us to Part 3. Are soldiers actually considered workers?
So the real anchor here is Section 23 of the Constitution, which boldly states that every worker has the right to form and join a trade union. Now, to figure out if the military's ban on unions was unconstitutional, the court first had to decide if a soldier legally even qualifies as a worker under this specific section. Because if they're workers, they have the right to unionize. If they aren't, well, that constitutional protection might not apply to them at all.
When you compare the two, soldiers are a lot like civilian employees when it comes to the basics. They receive salaries, they earn leave time, they get medical benefits. But they're a totally different beast when you consider they face criminal liability for workplace misconduct. Unlike a civilian who signs an employment contract and maybe gets fired for showing up late, a soldier enrolls in the armed forces. They are bound by a strict military discipline code. If they refuse to do their job, they don't just lose a paycheck, they could go to military prison. So it's an employment relationship, but obviously a highly unusual one.
To sort this out, the court turned to international law to help interpret the Constitution, specifically the International Labor Organization, or ILO.
The ILO actually broadly defines members of the armed forces as workers. South Africa had ratified key ILO conventions back in 1995, which clearly included armed forces within their scope. But crucially, the ILO leaves it up to individual countries to decide exactly how far those rights extend, based on their own national security needs. This prompted the Constitutional Court to interpret the definition of worker very generously, concluding that yes, soldiers do indeed count as workers under the South African Constitution.
So, let's dive into Part 4, the most contentious issue of the whole case, the right to unionize.
The government fought back fiercely on this. They argued that allowing unions would completely destroy the strict discipline required to manage a military force, and by doing so, would threaten national security. They pointed straight to the Constitution itself, which explicitly demands that the defense force be structured and managed as a disciplined entity. The state was terrified that if soldiers could unionize, they'd demand the right to strike and engage in aggressive collective bargaining, which would completely undermine the rigid hierarchy and prompt obedience a military relies on to actually keep the country safe.
But when you zoom out and look at this from a comparative perspective, international norms vary wildly. Sure, the United States, the UK, and France ban military unions outright. But look at countries like the Netherlands, Germany, and Sweden. They prove you can absolutely permit military unions without sacrificing military discipline. In those countries, unions might not have the right to negotiate pay or go on strike, but they act as vital channels for consultation and representation. The court realized that permitting a union doesn't automatically mean permitting chaos. Actually, scratch that. It's more like providing a proper channel for grievances might enhance discipline rather than diminish it.
So, how did they balance all this? Let's look at Part 5, the court's final verdict.
The court ultimately decided that a complete, blanket ban on both freedom of expression and trade unions went entirely too far in a democratic society. While the military definitely has a legitimate need for strict discipline, stripping soldiers completely of their right to speak their minds or form an association to represent their interests just isn't a reasonable or justifiable limitation of their rights. Those bans in the 1957 Act were officially ruled unconstitutional. Here is exactly how they practically fixed the law. First, they used a neat legal technique called severance. They essentially took a red pen and permanently crossed out the unconstitutional words regarding public protest from the text of the act. The ban on strikes remained, no one really disputed that, but the ban on peaceful protest was gone. Second, they invalidated the total union ban. But third, they didn't just instantly allow unions to form the very next day. They cleverly suspended this part of the ruling for 3 months. They recognized that dropping unions into the military overnight without ground rules could be a disaster. This 3-month grace period gave the military time to draft proper, strict regulations, like dictating exactly how unions could access bases or what specific topics they were allowed to discuss before the constitutional change took full effect.
I want to leave you with this profound thought from Justice Sachs, because it perfectly hits the nail on the head as to why this all matters. He wrote that a blindly obedient soldier is actually a much greater threat to a democracy than a soldier who is treated as a citizen in uniform. A modern democracy doesn't want mindless rule followers holding the weapons. It needs conscientious individuals who understand the rights and respect the rights of others, even while maintaining rigorous military discipline. So the next time you think about the military, ask yourself, does stripping away someone's rights really make them a better protector of those very same rights?